This is a matter before the Idaho State Board of Land Commissioners in the state of Idaho in the matter of the encroachment permit application number L-96-S-02061 Sourdough Point Homeowners Association. Cheryl Rise as president and applicant. Agency case number PH-2026-NAV-20-002. Office of Administrative Hearings, case number 26-320-06. This is the time and place for the evidentiary hearing. I'm sorry, sir, that's not as loud as it goes, so I will try my best.
It's good, thank you.
For those of you who have not participated in any of our pre-hearing proceedings, I wanted to go over a little bit of the order and the specifics of what to expect here today. First and foremost, my name is Leslie Hayes. I am an administrative law judge with the Idaho Office of Administrative Hearings, assigned to adjudicate these proceedings. To my left, Ms. Richter is with the Idaho Department of Lands as counsel. Please do not read too much into the fact that we are sharing a table together. That's just the realities of limited resources as we travel around the state of Idaho. We have objector Kevin Palmer here present as well. And we have the applicant present, I believe. And is Chris Good here?
I represent the group, yes.
Okay, so Mr. Good and Ms. Reese are here to represent the Homeowners Association as the applicant. I have a list of individuals who desire to testify here today. So the order of proceedings is going to be Ms. Richter first, as she's going to present the Department of Land's position under their regulatory authority. Next, the applicant will be able to present anything that they desire to present in addition to what the Department of Lands has presented. And then the objector will be given an opportunity to present, and then Lands and the applicant can respond to the objection. Once we are done with that process, we will open it up for any public comment. We only have this facility until 8 o'clock tonight, so I will stress that if we need to, we will place limits on the public testimony. That does not limit your ability to participate in these proceedings, because I will leave public comment open until the statutory deadline of April 15th. So what that means is if you don't get to say everything you want to say here tonight as a public participant, you will be given an opportunity to do so up until April 15th by submitting a written comment to the Idaho Department of Lands. As for the order in this proceeding, my order is a recommended order, which means it is not a final agency order. It is simply a recommendation to the director of the Department of Lands, who is the person with the authority to issue a final order in these proceedings. That final order is due 30 days after the close of evidence, which will be April 15th. So on or around May 15th, the director will issue a final order based on my recommended order, either adopting it, rejecting it, or a little bit of both. That means my recommended order is due 2 to 3 weeks prior to that, or 1 to 2 weeks prior to that, so that the director has the opportunity to review the file and the record before these proceedings, before issuing his final order. That order, for anybody that's online or here in person, if you would like to reference, will be posted on the Department of Land's website at idl.idaho.gov. So a copy of that order that's where you will find it. So with that, I will turn it over to Ms. Richter.
Thank you. Okay. Thank you, hearing officer. Before
You're gonna have to roll that.
okay, there it is. Can everybody hear me?
Yeah.
Okay, great. Before we take up testimony from Mr. Amer, can we address some of the exhibits?
Yes.
I don't have an objection. Well, IDL has an objection to one exhibit, which is the objector's SH38. It is a copy of the rules for the navigable waters. It appears to be from 2000. I did provide an updated copy of the rules as Exhibit IDL 13 for the record.
copy of that exhibit number?
SH 38.
Can't hear you, say something. Yeah. We can't, I don't can't hear.
Okay, give me just 1 second.
So with that, Mr. Palmer, and I'm just gonna yell at this point in time, because we're dealing with preliminary evidentiary issues. With that objection to SH 38, IDL has objected on the grounds that you have used outdated old regulations that are no longer in full force and effect. I will let you respond to that objection. Probably the easiest is during the presentation of your evidence, given the volume and the one microphone issue. For what purpose you have offered that exhibit before ruling on that objection.
And the second pre-hearing matter about exhibits that I wanted to address is regarding applicant or the objectors SH 59, which is a bunch of photographs. This is not quite an objection, but it appears perhaps pages 47 to 65 may have AI generated renderings of the possible encroachment, and if the objector could clarify whether those are AI and if there is other AI use throughout the exhibits as well.
So Mr. Palmer again, and did you get that objection? Okay. Yeah, you guys can all, you don't have to be afraid of us. All right, we're gonna take a quick break while we figure this out. All right, for those of you in the room now, if I use my big voice while you're closer, can you hear us? Okay. Okay. Just in case you.
All right. Okay. With that. Test. Okay, how about now?
Yes, there you go.
All right, hearing officer, may IDL call Mr. Amer?
Yes, Mr. Amer, will you raise your right hand for me? Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Mr. Amer, what is your name and title?
My name is Mike Gamer. I am the resource supervisor for the Navigable Waterways program.
How long have you had that title and what did you do before?
I have been the supervisor since 2018. Prior to that, I was a resource specialist from 2014 to 2018.
So you've been in the Navigable Waterways program for 12 years?
Correct.
Roughly how many permits or applications would you say you've worked on or with in those last 12 years?
Well over 3,000.
What areas do you oversee as resource supervisor?
I oversee our St. Joe office, our Coeur d'Alene office, our Sandpoint office, and our Priest Lake office. So basically everything from the St. Joe River up to Priest Lake and everything in between.
Are you familiar with the application we're here discussing today?
Yes, I am.
And are you familiar with the area where the proposed dock is located?
Yes, I am.
Does anything stand out to you about this particular application?
Yes, I'm not aware of another site in North Idaho that has the setup that Sourdough Point has, with the basin fully enclosed with the narrow channelway, it being a community dock, and then there being a mix of individual community docks and then a large community dock and then private docks along the western shoreline there. I'm not aware of any other facility like that in our area.
Based on the objector's comments and exhibits, it seems like the line of navigability is the crux of the issue for this application. Can you briefly explain what the line of navigability is?
Yes. The line of navigability is defined in IDAPA, which is our state rule code book, our rule book for processing these applications. And it's defined as a line located at such distance waterward of the low water mark established by the length of existing legally permitted encroachments, water depths waterward of the low water mark, and by other relevant criteria determined by the board when a line has not already been established for the body of water in question. More simply, the line of navigation is connecting the dots of the end of all of the docks along the shoreline, but all of the permitted docks.
Do ideal procedures address the line of navigability for community docks?
They do. Our ideal procedures for community docks states that the line of navigability is typically not applicable to community docks or commercial marinas. Because if you were to think about a shoreline that had a whole bunch of single family docks that were 60 feet in length, and then there was a marina there that was going to be a 150 slip marina, that would mean that the 150 slip marina can only go out 60 feet. So the line of navigability is not applicable to marinas or community docks because they inherently are much larger in size and have way more moorage than other single family facilities.
Can you explain if there's a difference between the line of navigability and the common or established path that boats take on waterways?
Yes, Department of Lands does not regulate vessels. And so the line of navigability, as I described before, is connecting the dots essentially at the end of all the docks. And the line of navigability is established to set a length for single family docks. You don't want to have a situation where there are 60-foot docks and then all of a sudden someone's going out 100 feet. That one dock that's 100 feet would kind of stick out like a sore thumb and essentially can be a hazard to navigation if someone was navigating at night. So that's the line of navigability. The path that a boat may take and drive around the lake or inside your basin is not the line of navigability. That's just the path the vessel will take. And again, Department of Lands has no jurisdiction over vessels.
Do you see an issue with the line of navigability and the proposed community dock expansion as part of this application?
No, I do not, because as mentioned before, it's in a unique basin area that consists of private docks, community individual docks, and a large dock. And the basin is deep enough for the 6 homeowners on the western shore to navigate to their dock. So it's deep enough for those folks to get to their dock. The inlet channel that allows folks to go in and out of the basin to the main lake is 65 feet wide, roughly, measuring it on the aerial photograph. So if boats can easily navigate the 65-foot width coming in and out of the lake and the basin, the proposed dock expansion will provide a 71-foot buffer from the edge of the proposed expansion to the nearest dock to the west there. So again, given the fact that it's in a basin, it's contained in a basin, and given the fact that folks are navigating a 60-foot wide channel to get in and out, and given the fact that boats can access the private docks to the west, I don't see that there would be an issue with line of navigation if this were to be expanded to the west.
Thank you. And last question, to your knowledge, does IDL have the authority to determine property ownership?
No, we do not. It's usually handled in a regular court case.
Thank you. And that's all that I have for Mr. Amer, but the hearing officer, I understand that some folks may have questions regarding ownership that I think are more less evidentiary and more legal arguments. So to the extent that you would like additional argument or briefing on that issue, IDL would request to do any post-hearing briefing if necessary.
Okay, thank you. Question, Mr. Amer, and you might know Ms. Richter's intent, but is the property ownership question and Ms. Richter's intent of asking the actual ownership of how these docks are managed and passed along amongst the homeowners collectively?
Yeah, I'm sure you're getting there.
Do you understand what I'm asking?
Yeah,
Okay.
I can try. the way that a community assigns spaces or organizes the slips of a dock, is that something that IDL has jurisdiction over or has input on?
No, so when a single family property sells and there's a dock there, there's an assignment process to transfer that permit from the seller to the buyer. And that happens all the time with all the times that properties sell. When the permits are issued to the owner. And so in your guys' case, the permit is issued to Sourdough Point, the HOA, or I'm not sure if you guys are HOA, but the Sourdough Point is the permit holder. So if someone were to sell their lot and they had a boat slip in the big community dock system, or they had one of those individual docks, if they were to sell their lot, there's nothing that needs to be transferred because the permit is still in the name of Sourdough Point. So it's strictly an internal situation. In some cases, if you could think of a dock that extends out into the lake, the slips that are closest to shore are probably less desirable because they're shallower. We have no control over who gets that shallow spot versus who gets the outer spot. That's a completely internal HOA decision about ownership of the docks and ownership of the slips and who gets what slip.
Thank you. Yes, sir.
But it does go with the dock, correct?
So public witnesses are not here to question Mr. Amer. Only the parties participate in this proceeding. To the extent you have questions about any of the testimony for IDL and its regulatory authority following the close of these proceedings or on a break, you're welcome to approach Mr. Amer and ask that question.
And that is all that we have.
That's all that we have.
Okay, does the applicant have any questions for Mr. Amer while he's in the hot seat?
Yes.
Okay, can I get you to come up here so you're closer to the microphone?
It might read him.
How do you establish, it's our understanding that low water mark establishes a area of navigability or not? And how is it that, I'm speaking to the applicant, I'm asking, the issue of the low water mark, we quoted here, and this is, I want clarification because we want to most understand how you would say this. So say that, quote, the line of navigability, and if you can help us with this, is defined as a line located at such distance waterward of the low water mark established by the length of the existing legally permitted encroachments, water depths, waterward of the low water mark, and by other relevant criteria determined by the Board of Land Commissioners when a line has not already been established for the body of water. Is there a low water mark in our marina situation?
Okay, I would first start off by identifying that with Lake Pend Oreille, it's the one unique lake up in northern Idaho that has an artificial high water. Every other lake up in our neck of the woods has an ordinary high water. And so when the water drops in the winter, there is a low water mark. For the purpose of Lake Pend Oreille, you guys have the artificial high water mark, which is the summer pool elevation of 2062 during the summer. When the water drops in the winter, that is the ordinary high water mark. So, I mean, technically speaking, I don't know if there is a low water mark for Lake Pend Oreille because I guess low water mark and ordinary high water mark are going to be the same for Lake Pend Oreille. I would also follow up by saying the definition talks about, I believe, 3 separate criteria. The first is the distance waterward to the low water mark, or it could be established by water depths, or it could be established by other relevant criteria determined by the board. So it doesn't have to be all 3 of those. And in your lake, there could be cases where the water mark is the low water mark, which we could call the high water mark, might be in the middle of your dock. Someone could have a 60-foot dock, and when the water drops, the low water mark is only 30 feet, it's only halfway into your dock. So that doesn't mean that is where the line of navigability is. The line of navigability, again, is primarily used by my team and myself to determine the length of docks in the area. It's not to determine the path of boats. It's not to determine how vessels drive. It's primarily used for single family and 2-family docks to make sure, going back to that example, to make sure that there's not 60, 60, 60, 60, 100, 60, 60, 60. That's what the line of navigability is primarily for. And so with your lake being unique, I would say it's other relevant criteria, which is gonna be the length of the existing docks as well as the depth. If everyone is at 50 feet for their dock and they get to 12 feet of depth and someone says they need to go out an extra 20 feet, what is the purpose of that extra 20 feet? You already are at 12 feet of depth. Like, what was that purpose for? It seems like that would be then exceeding the line of navigability. But it is a unique situation in that the low water mark for your lake, I believe, is also akin to the ordinary high water mark.
Thank you.
Any other questions?
No. Any other questions?
No.
Nope. Okay. Mr. Palmer, as objector, do you have any questions for Mr. Amer?
2 minutes. I'm good.
Okay. Ms. Richter, do you have any other witnesses?
No.
Okay. Normally I don't do this, but because these exhibits were given to us before the hearing, but after our pre-hearing conference, I would like Ms. Richter to entertain me and at least let me hopefully understand what it is she has provided to us here today as additional exhibits. This is just merely a housekeeping matter. So if you don't understand what I'm talking about, it's merely because we got exhibits at a late hour and I want to make sure I understand what these are before we close the proceedings so that we don't get into a procedural hiccup on the eve of my order needing to be issued. So I did understand that IDL 13 are the IDAPA regulations, the current IDAPA regulations. And then there is IDL 14. What is this document?
That is the original plat for Sourdough Point from 1961.
And IDL 15, I know your exhibit list had some of this, but like I said, just want to make sure I understand.
IDL 15 is the 1966, sorry, I'm getting a pop-up. The 1996 First Amendment to the plat.
IDL 15 is a plat amendment.
The first addition to Sourdough Point plat. So it's the second phase of the development.
And IDL 16.
It is the 1968 second addition to Sourdough Point plat. So it is another phase in the development.
And IDL 17.
That is the Sourdough Point Owners Association Articles of Incorporation from 1976.
And there we go. That's 17. Making me go through my paces, making these double-sided.
There were 113 pages and I thought it would be.
IDL 18.
That is a warranty deed from 1979, conveying land, including the recreational island as shown on those plats of Sourdough Point subdivision from Hazel B. Moon, Hap Hike Inc. Corporation and Sourdough Company to the Sourdough Point Owners Association. And that is a warranty deed from 1979.
And then IDL 19.
That is the 1982 first original Sourdough Point Owner Association encroachment permit for docks within that lagoon. I'll note that in 1974, the Lake Protection Act was passed.
So there have been some portion of, well, this might be better for Mr. Amer. There have been some portion of the Sourdough Point community dock that has been permitted since 1982. Is that your understanding of these documents?
Correct.
Okay.
the naming convention of the permits, indicates that there are parent applications, that were related to the instant one. So this, for example, this application is L96S 026, no, 0206I, which means this encroachment permit has parent permits, none, and then A through H.
All right, and that's a fact-based testimony. So Mr. Amer, you just heard Ms. Richter's explanation of the naming convention for the Department of Lands and the I designation on the current permit. Do you agree that that is IDL's policy?
Correct. Every time a new permit gets issued, we add a new alpha character to it. So it's A, then B, then C, D, and so on. Eventually, we may get to AA. If we stick around long enough.
And then IDL 21.
I think we skipped IDL 20.
IDL 20. IDL 20.
Thank you, sorry. That is a survey of the recreational island from 1996.
And IDL 21.
That is the copy of the 2023 Sourdough Point CCNRs.
And IDL 22.
That is a copy of the 2023 Sourdough Point bylaws.
And IDL 23.
That is the current encroachment permit. That is the parent of this application. It from 2024, encroachment permit number L96S0206H.
And IDL.
That should be all.
That should be all of it. Okay. And then we had left exhibits open at the pre-hearing. But with your objections, I think it's still premature to take up stipulations. I will take up stipulations to the unobjected to exhibits. So from applicant, do you have any objections to IDL 1 through 23 being admitted?
No, we do not.
Okay. Mr. Palmer, from objector standpoint, any objections to IDL 1 through 23? Okay, so IDL 1 through 23 will be admitted pursuant to stipulation. I'm going to leave the objector's exhibits open at this time. Ms. Richter, any objections to applicant's exhibits as presented?
No objections.
Okay, Mr. Palmer, any objections to admitting applicant's exhibits? Okay, so applicant's exhibits will be admitted at this time as well. I will take up the specific objections to SH 38, SH 59. I believe I saw an unredacted copy of SH 25 submitted. So with that, do you continue to have an objection to that exhibit, Mr. Good?
No, do not.
Okay. And then what was the other exhibit that you, the redacted exhibit that you had objections to?
I don't recall. We did submit it, right?
Um,
Like that.
Do you recall seeing an unredacted version of that document? Okay,
Yeah.
so I will find that document and we will take that up, but do you have any objections to the other exhibits as offered by objector being admitted at this time? If it,
Do we get a chance to challenge them or ask questions about those?
yes,
The witness testimony
Admit-
particularly?
admission of exhibits is different than weight. So weight is what I do on my end of things after all of the evidence comes in and the testimony comes in. So if a document contradicts testimony, I can assign the testimony less weight or the document less weight in my fact-finding mission. Admission just says that it's a document that I can consider while I'm doing my process of the findings of fact and conclusions of law.
Understood. There's no objection.
Okay, so I believe it was, do you recall, Ms. Richter?
Of the original,
The objections that were raised at the pre-hearing related to redacted documents. Okay, I'm going to reserve ruling on objectors exhibits until we can find that. I'll ask for you to look through them on a break and see if you can identify them.
Okay.
Okay. And we will move forward with these proceedings. So, Mr. Amer, are we all done with him at this time, Ms. Richter?
we are.
Okay. So with that, it's applicant's turn to put on a presentation of evidence. To the extent you have anything in addition you would like to add to what Mr. Amer provided, the floor is yours. I will ask for you to sit down, Mr. Good.
Okay. And is there any place I can plug in? I only have a few. Two of these.
What are you trying to do?
Present, an image.
Okay. Do you need a computer? Is that what you're?
Yeah, wherever it was, whatever's plugged
Okay.
into that one.
You
Yeah.
can.
Could do that. I can click on it. No problem.
Oh, Mike's on.
Okay, we'll go on a quick 30-second break while we're getting the text set up. All right, we are back on the record. Mr. Good, I assume you're going to be providing both background and fact-based arguments, so I'm going to place you under oath. Will you raise your right hand for me? Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay, floor is yours.
My name is Chris Good. I'm representing the applicant Sourdough Homeowners Association, herein referred to as SPOLA. For reference sakes, note that the location of the proposed dock extension variously referred to as SPO Lagoon or Marine. As been historically true of the wonderful SPO community that we have, there are many expected objections, changes. The good news for this application process is that the majority of the community has voted in favor of moving the process forward with respect to two motions that were made, with the board subsequently following up with their duties to follow and execute the community wishes to the extent that the board would consult with its community members and its committees. The submission of the permit application by the SPOA board brings us to today, where we have a hearing and a public opportunity to discuss that. I'm going to review just a short history, which will clearly be outlined in, I'm sure, all the documentation showing improvement at the time of our community dock system. And I'm going to skip, actually, thank you so much for the preliminary remarks with respect to navigability. Just not going to address that. We super accept the details that IDL's provided in the submission, and I won't address any of that. I will say a few things about boating safety, and we will address at least some of the new points that came up. One was swimmer safety. And I'll make a couple other points about boat channel dimensions. and then try to conclude my remarks. That's where I'll proceed. So thank you for bearing with me, and let me know if you can hear or if I'm hopefully speaking slow enough, clearly enough for all our online members. As it goes for this, if I have exhibits, I'll see what I can do to address those and point to the points of interest that I have. Earliest, and this is history as I understand it today, then in 1992, SPOA began planning a community dock system in the lagoon to provide additional boat slips for SPOA members who did not have a boat slip. Not unexpectedly, the idea generated controversy, and there's differing views, opinions, thoughts, and it took several years to resolve those issues. There was a lot of work done by a lot of people, a lot of conversation. It did result eventually in 1999, record which showed the construction of the floating dock complex that eventually resulted in 32 boat slips. By 2007, there was interest in adding additional floating docks for the remaining SPOA members that did not have a boat slip. Second occurrence. And I'm going to refer to my first one is the SE2. And I think that should show up. Yeah, here. See if it'll open up the computer.
Real quick, I'm sorry, Marty just texted, do we want to show the slides somehow throughout the Zoom? I don't know if you could put your camera on the.
So what we could do is if you log into the Zoom call, we can share your screen to the Zoom call.
Okay. You want to pause on that or do you want?
Okay, we're gonna do another tech break so that you guys can watch the slide show as well.
Thank you.
All right, we are back on the record after enabling screen sharing capabilities for those participating online. So I will turn it back over to you, Mr. Good. You may want to turn the camera off. It's hitting you right about your midsection.
Thank you.
Yep, the floor is yours.
Thank you. In 2007, there was an interest in adding additional floating docks to the remaining members that did not have a boat slip. Referring to the slide that's in front, exhibit SD2, the plan at one point was to add 20 additional slips, which was envisioned as enough slips to provide all interested SPOA owners with the boat slip for the lagoon. However, the plan was ultimately scaled back only to add 16 additional slips because not all the dockless SPOA owners were willing to pay for the new docks. You can see also the alignment change that happened subsequently. So what's important from the historical presentation that I'm providing is that SPOA has two overarching principles regarding docks in the lagoons. Also, number one, all SPOA members should have equal rights to a boat slip in the common area of the island lagoon. Second, SPOA members receiving a boat slip should pay all costs associated with permitting, constructing, and maintaining the docks that provide the slips. As a result of all the deliberations and process, a 16 dock slip expansion was completed in 2009, and as you can see, the existing 32 docks were slightly repositioned in the process. And today, we have 48 slip dock complexes.
Excuse me, sorry. Is this one of your exhibits?
Yes.
Number 2.
Number 2? Okay, I just wanted to
Yes.
get that on the record.
Exhibit SD2.
Great, thank you.
Today, we're now proposing to add 4 additional slips for a floating dock complex. We believe, if you're wrong, this will be the last edition of the boat slips in the SPOA Marina, as all non-shoreline SPOA lots, with the exception of one owner, didn't want to participate with the cost. Lots will, that all then will have a boat slip for the marina. The current permit application effort began 3 years ago. True to the process of SPOA, we had lots of discussions about dockless owners, the proposed addition, and the general controversy among SPOA members. Respectfully, people's opinions have been heard. There were 2 motions that were at our annual meeting, and I'll present those images. Let's see,
Mike.
where's the original?
Yeah, let's close out of your email, Mike.
Down there. Okay, perfect. It's gonna be that one. That one? The other yellow. Okay, so, okay, thank you. And I will call for exhibits SD3A. And I will pull that up. And we had a motion to allow the 4 SBO members who do not have boat slips and who are requesting equal access to the SPOA Marina to build slips in the SPOA Marina. Cost for constructions and permit would be borne by those 4 members. The location to be determined by the dock committee in consultation with the board and in accordance with the requirements of regulatory agencies. That passed at the annual meeting after discussion among the members, with a majority voting for the passing of that motion.
That did not pass.
I call to the second, which is
Well, let me address the comment from the audience. When you're called up to provide public testimony, you are free to
Okay.
provide
Great,
evidence
so
that
then,
contradicts. Yeah.
I call the second, it's exhibit SD3B. And in this, let me see if this works here. Oops. Can't get it any bigger than that, I'm sorry. And then the second motion went forth with defining the area to include the addition of the extension of the floating dock. That motion was also passed after discussion at the annual meeting, and the motion was on June 12th, 2024, Carl Vetter made a motion to limit the location of personal moorage for docks within Sourdough Point's existing lagoon dock configuration. The area outlined in black would be where the personnel moorage docks are permitted. The exception to this would be for those who own shoreline properties. Motion submitted by Carl Vetter, seconded by George Lockhart, and that passed with a majority vote at the annual meeting. Following that, the board asked the dock committee to look at all the available options in the approved lagoon area and ultimately found that the only viable solution for the proposed extension was to the west end of the floating dock complex. Other options, either severely restricted navigational lagoon, movement of the vessels, too shallow, rocky, or exposed to wave action. They made recommendations to the board and they moved forward. I'm relying on IDL, and I'm skipping through all our presentations on lines of navigation, because that was explained clearly about what needs to be maintained there. And I will now address some of Mr. Palmer's concerns. As a group, we've received some of these lately, and we'll work with that. So boating safety. I I understand Mr. Palmer's concerns about boating safety. I think we all have those. Particularly with respect to any shallow waters, obstructions, congestion. As I mentioned, the entire lagoon is, the IDL confirmed it's an enclosed piece of land. It's a very interesting, unique situation, but it is a no wake zone. It's very clear that that's what our rules are for that. Historically, the marina docks have been used for boat size for small types of recreational vehicles. Those sizes may be increasing as people have interest in having larger vessels. But there is, in my knowledge, no community-wide agreement or plan for dredging or having significantly larger floating docks installed within the existing community dock system. There may be some interest, but at this point, we are not aware of anything of that. Private owners may, with shoreline property, may have different needs, respecting that. We do have one other exhibit here. Both you. Yeah. And this is a little redundant. Thank you for IDL presenting this clearly more than we could. But if you start with and you look at this, you can't go and see it at the bottom.
Careful.
Okay, yep, okay, bottom picture, you'll see the new extension of Mr. Palmer's beautiful deck system there. And just at the bottom right, you'll also see the original 20-foot one that was there from the prior owner. So the use of those docks for his private ownership will be the new dock actually extends 60 feet into the lagoon from the shoreline. And you can also see it is in fact the largest dock in the dwarfing all the original 20-foot docks that was in his property, but also others. And that's, I think, for us, a clear indication that the needs of the community, what the private ownership is doing with docks have changed. But we also note that the inlet, we talked about that, the community at the top there, A, it's referred to as the causeway. It's the only entrance to the lagoon, and most boats at full pool and other use this as the entrance and exit. It's possible people might go under the bridge with a canoe or a small kayak or something like that. But when you get to the actual narrow point of that point A, you get to actually where the posts are. By our measure, we're saying is you start about 38 feet of trying to get your boat in there. My experience, even coming in at night with boat lights and all that stuff, you just have to, you got 38 feet to work with. You also note the passageway at label B, where the close point is with the point there, is a pathway navigable width about 48 feet. And it must be traversed by all the boats who want to access the other side of the docks there. It's a common pathway. It's been existed for years, actually since the inception of the building dock system. We find it, if there's an argument for vessel navigation and then how difficult that might be for cutting through a 38-foot cut in the causeway, and then for us on the right there, eventually there'll be a 70-foot wide channel. For coming into one's personal dock, I'm not sure how much space we need more than starting at 38 and moving to 70 and be able to navigate the vessel. Maybe the vessel is very large. I might say that for us, maybe you use side thrusters to move 3 or 4 feet, navigating left and right in a 60-foot causeway. It's hypothetical, as we talked about. It did describe that ideal sense of if you had a line of navigation. The point being is not so much a hypothetical yellow line that says, oh, gee, that would be the line of navigation if you had one in closed marina, which basically you already said it's not relevant. We support that position. But if you ask yourself, when you build the dock here originally, Mr. Palmer said, gee, what's the line of navigation? Well, that kind of would have been it. But now to establish a straight line, say that's my personal line of navigation that's necessary for my vessel navigation. We don't see the argument. What's important to say, though, is that quoting Mr. Palmer's claim in his objection, that his new dock permitted in 2024 was, quote, designed specifically in alignment with the current navigability line. Those are Mr. Palmer's contention. My statement is to suggest that, well, did you recognize that the line was, as we've been proposed, I think, originally, before you built your big dock, is the yellow line? Or is it now that we're building a dock and we say, gee, now we're gonna develop a new line of navigation? I don't know if it's relevant either way, given IDL's position on what lines of navigability are inside of marina. But our point being is, one way or the other, the argument about designing one with an alignment with the current navigability is a question for us that we don't support. Stay with me, I got a few more points. Try to keep with this. The water depth was addressed.
Can I ask you a question
Sure.
about this SC4? So it looks like this yellow line, you have 1, 2, 3, 4, 5, 6 docks
Yeah,
that are shoreline property owners in the subdivision. And then would all of these other docks to the top of this U shape be community, single family
my
docks?
understanding, yes.
Okay. And then that U shape above the yellow line is what's referred to in the record as the island.
Yes,
Okay.
yes.
Thank you.
Thank you. Question about swimmer safety. That's a new issue being highlighted by Mr. Palmer. Has raised concerns about the safety issue related to swimmers, paddle boaters, kayakers, and congestions of boat traffic from the proposed dock extension. I don't know if he will, but I think he pre-submitted some pictures of family, friends, or whoever swimming in the lagoon. Looks like fun. SPOA does not have any prohibited for swimming in the lagoon. It's rarely actually used that way. Given that SPOA has designated swimming areas roped off with beach access. Some people swim around the island, some people do a lot of different things. I can understand that you want to work in your area where it's close to your dock. On the other hand, there's no prohibition against people swimming in that area. To quote, and then I think there was a following document that was said that there was a rule against SPOA documents hiding that no boating in a swimming area. I look forward to hearing the rationale around that, because if you had swimmers in your own boat dock area that you couldn't bring your boat in, at the same time, the swimming area that's designated actually is on the other side of the island. That's where the designated swimming areas are. I would look forward to hearing a little bit more about how that might be resolved on a safety issue from the use of those paddleboards and swimmers and prohibiting boats from coming in through there.
So Mr. Good, I do have a question about that for you. So, and I'll just hand it to you. So the SH 48 that Mr. Palmer submitted as part of his objection, are you disputing that document is not a document that currently exists and is in full force and effect with the homeowners
I
association?
actually think it is full force and effect, and it is actually accurate. Boats are not allowed in swimming areas.
Okay.
My point is, where are the swimming areas? It is an area where there are boat docks in a marina, a designated swim area. That would be really interesting collection. And then I think also the idea of a community member saying, by the way, the rest of you have to agree that this is a swimming area, no other boats can get in there for all the members in the marina.
Ms. Richter has a question for you.
Sure.
Sounds like.
When you're talking about swimming areas versus designated swimming areas, are you saying that there is an area within the lagoon or on the
Beach side of the island.
beach side that is
Not in the
specifically,
lagoon or in the marina.
okay, okay, beach side of the
That's what
island.
regulation is, my understanding, controls.
So to clarify, there is a specific separate swimming area
Yes,
that
yes,
is not within the
understood
lagoon.
by the membership, yes.
Excellent.
Yes.
I understand. So I just wanted to clarify that
Yes.
you're saying that.
You'll all be having an opportunity to clarify any of these
Yeah.
points when we take public testimony.
Yep.
Yeah, that that you're understanding that policy to mean no boating in that designated.
Correct.
Okay,
Yes.
this is. If you would like to, this is your, I'm giving you your.
Okay, so this guy right here.
Okay.
Yeah,
So,
that's a swimming pool.
so it's this right here.
Okay, so the witness's testimony is that in SD 4, up by the letter B, if you go to the land side of the beach to the lakeside outside of the lagoon, that's his understanding that that is the homeowner's designated swimming area.
Yes, and those regulations will apply to that. That's my understanding.
That's where the.
Maybe I'm wrong, but that's my understanding.
Anybody that's providing public comment is free to contradict your testimony. This is just based on your own personal knowledge. For the audience benefit of why I articulated what he was describing in the photograph is because the record cannot distinguish between it's there, that's it. That does not provide me any usable facts for purposes of these proceedings.
Yes. There was also introduction by Mr. Palmer about saying that the current dock system is underutilized. And that there were testimony from other members to saying that there's a lot of empty boat slips. That might contrast with saying that it's saying it's a busy marina. It's my contention, to my knowledge, that there's never been a single boat collision with the summer swimmers, thank God, kayakers, paddleboarders of any kind in the history of the marina. It's a no wake zone area. People know when they're in the lagoon that they have.
So I need members of the audience to just kind of keep your commentary to yourself. It disrupts the recording and the proceedings. All apologies. It happens at every public hearing. I know it's really hard, but the process is what the process is and we have to follow it.
We had one last point about the boat channel dimensions, meaning about talking about the fairway, what would become the new dock extension. So the current channel width would be without the additions is 91 feet at its narrowest. And that would be from the existing dock to Mr. Korn's closest dock. Our latest estimate, if we just did the addition of the 26-foot extension, the T off the end, is that with the new channel width corrected for, it's a little bit offset, the position of that whole system to Mr. Korn's dock, but we're measuring 67 feet. Somebody quoted 70 by GPS, but we're saying 67. I invite everybody who has a contention about, is there enough room here, to simply come to the lake and look, when we have the hearing, public viewing the dock area tomorrow. That would help to clarify some of these matters. But if you look around the Lake Ponderay, the whole area, and you can look with GPS, it's pretty easy to use the tool. You find that nearly every marina in the lake with the has a width of 45 feet fairway or less in it. For example, the gas dock at Sand Creek has a 38-foot fairway. The Sand Point Boardwalk at one point has a 36-foot fairway. Notably, Toppler Marina, which submitted a statement of objection in Lake Coeur d'Alene, part of their marina there has a 44-foot fairway for their 28-foot dock slip complexes. Our nearby Bottle Ray Marina complex has an entry that measures 42 feet. For me, it's a reasonable conclusion to say that the fairway of 60-something plus feet is large enough to get a vessel through with a competent boating captain. Finally, I think close out my remarks. I'd like to say, by Mr. Palmer's own drawings of his objections, and maybe I don't understand them, and we'll look forward to hearing this presentation, submittal, shows that it's difficult or it's awkward, or he cannot drive straight from his dock to the causeway cut and exit the lagoon without having to navigate or turn or get around an existing floating dock system. Making an additional minor adjustment if the new dock is permitted, it's, I believe, in our contention, it's hardly a restriction of navigation, and it does not create an unsafe boating environment. We ultimately assert that SPOA's littoral rights are not inferior to that of Mr. Palmer, and that the single neighbor's private dock design does not create a permanent legal ceiling for the entire community's navigable rights, including the community docks. We believe the proposed extension meets all technical requirements of the Lake Protection Act. It serves the broader community interest and should be approved by the director.
Thank you. Ms. Richter, any questions for this witness that you haven't already asked?
No, thank you.
Okay. Mr. Palmer, do you have any questions for Mr. Good that you would like to ask?
Well, Mr. Good did actually kind of give you a sneak preview of some of the things I was going to talk about and didn't present what I was actually going to say. So he actually represented his thoughts on what he thinks I'm going to say. So I can simply do my presentation, and when we get to different things, we can dismiss some of it.
Okay, understood. So you are reserving your right to ask him questions until after the presentation of your evidence, or leaving it to me to weigh what you present versus what he represents your objections on.
Everything.
Okay. Any other, Mr. Good, individuals to testify on behalf of applicant?
None.
Okay. Mr. Palmer, about, you go back. Mr. Palmer, about how much time do you believe your presentation will take?
We will be done by 8, sure.
Okay, it's more, do I need to give the audience a bathroom comfort
I
break?
think that would be good. You just want me to connect to Zoom and have to deal with.
Okay, so let's take a 10-minute comfort break. I asked everybody to be back here at 5:27. All right, we are back. Not everybody from the audience is back from their break, but the time has come and gone for us to resume, so we will resume. The door out there does lock when it's closed, so we will keep the door propped open till it looks like the audience is filled back in. I understand that creates some noise issues for some of you, but rather than having people banging on the door to get let back in, that's my preference. So Mr. Palmer, it's your turn to present your position in this case. Mr. Palmer will have screen sharing set up to share what he is showing to the audience for those of our folks online. And so similar to Mr. Good, you will be providing both argument and facts in your testimony. So I'll swear you in at this time. If you'll raise your right hand for me, do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
All right, floor is yours. Oh, but before we start, I did pull up our pre-hearing transcript, or at least the VTT file that Zoom generates, and the objections were to SH21, as in Moorhead is not a dock owner from what the homeowners can tell, and they would like you to clarify that email a little bit more so that they could either argue what their objection is to that document for purposes of admitting exhibits. And then to remind you, IDL objected to SH38 as outdated rules. And I'm giving you an opportunity through your presentation to demonstrate what relevance those rules have to these proceedings. And SH59, questions on the photos and any AI generated materials that are contained within your exhibits.
Okay. May I sit? Is that okay?
That's fine, yeah. You may have to use the microphone if folks have trouble hearing you.
Well, you need about 3 arms or 4 arms. Yeah. Hey, John, you've got two. Okay, is this working?
Yes.
Yeah, but still talk loud.
Right.
Has to be close.
Roger that. Well, first of all, good afternoon. Great to be here. My wife and I always enjoy coming down to Sago or Sandpoint area. We've actually been coming here for over 30 years. And some of you think that we're just new in the area. Well, we're new in the Sourdough area, but we used to vacation a lot over near Hope. And I think it was Trestle Creek campground way over there. We used to stay at the Seasons, but just wanted to give you a little background that we're not these new just Canadians that showed up. You know, Canadians, we're part of the 51st state, and so we're just happy to be part of all of it. But it's a pleasure to be here. I think maybe that's not the right language, but I wanted you to just understand who we are. There was an objection by Safe Harbor Holdings, like who is Safe Harbor Holdings? So Safe Harbor Holdings is a limited, an LLC, basically a family-owned LLC that owns our property, our lakefront property. And so that's why I'm here, and that's who the objection was from. But it's just a family company that simply owns that property. As I said, we love the area, and I'll tell you, we love the community. Just recently, I received, I think it was John. I was talking to John, and John said, "Hey, did you know your Adirondack chairs have blown off your dock?" Yeah. And then Michael Bourne sent me a text, a picture of my Adirondack chairs down in the mud. And then I got an email from another family, Cindy, the Gab family today, saying it was a beautiful day today, and we thought we'd just go pull your chairs out of the mud, and that they needed good cleaning. So I was going to say, John, if you wouldn't mind taking care of that. But no, listen, and I'm not trying to be humorous here. I simply want to state that we love the community, the people here. And so here we are, and we're in a situation where our community, which we are members of, we're a part of, but we are private property owners, and we're also members of the community. And so our community has filed an application, and we objected to it. And but it doesn't mean that we don't love everybody here. We do, and we don't want this to be a contentious thing. We just want to kind of figure it out. And our position is we want to present as much evidence as we can so that Leslie and so that the Idaho Department of Lands can take a good look and understand what our objection is really about. It is far from just lines of navigability. That, quite frankly, that's irrelevant. The issues are so much greater, and we're going to walk through that. And I better remember to advance the slides here, and you can see this is the slide there in front of you. That picture is the area we're talking about.
It's not showing on the Zoom call. Are you sharing it with the Zoom screen? Okay, it shows that Mr. Palmer it started sharing, so mute that. Or I can do that. Okay, we're gonna once again take a short 30-second tech break, so we're not picking up extraneous audio while we figure this out. All right, thank you for those of you online. We figured out the tech issue. It was an extended desktop of two different screens and we were just trying to share the wrong one. So I think we have it all fixed and the floor is yours, Mr. Palmer.
Great.
And then I will ask that you submit this presentation following
Sure.
this so that it's part of the administrative record outside of the recording itself.
I will comment on the AI question. There is no AI used in this except for a couple of AI images that give a suggested view of what the additional extended dock would be. And I can identify those. In fact, anything we show that shows extended dock as a real life type image, that would be AI because the new dock extension is not there. So there is some of those, maybe 2 or 3 at the most.
So are you clarifying, are you saying that any image that references an extended dock was generated with the use of generative artificial intelligence?
Simply the extension, dock extension was AI, but everything else is a real image.
Okay.
Yeah.
And does that address your objection, Ms. Richter?
It does, thank you.
Okay, do you stipulate to the admission of the AI generated images in SC 59 to be weighed with the knowledge that that is how they were generated?
Yes, thank you.
Okay, and then applicant, any objection that you want to join on that front, or are you? Okay. So we'll take up SH 59 is admitted without objection, and we will take up 38 and 21 when you get to it in your presentation, and then we will discuss getting your exhibits that we, to the extent subject to the rulings on those objections, into this record.
Perfect.
Right.
I'm going to skip some of what I planned on talking about. I don't think it's necessary. I thought about talking about what an encroachment is. I think everyone here probably understands what that is. And so an encroachment, of course, is any structure or activity that occupies or extends into the beds or waters of a navigable lake, which would include things like docks, piers, bridges, and others. And I'm actually grateful that in the process of applying for an encroachment permit, that the Idaho Department of Lands is serious about notifying those that might be affected by that. And that's what we're going to be talking about today is how some of us, in fact, I believe the entire Sourdough Point community, not just lakeshore owners, are impacted by this proposal. I want to make it clear as well, I do not object to Chris and Tim and any others that want to vote. I don't object to that. What I object to is the location in this particular situation because of the impact it's going to have on so much. So we'll be talking about that. It's interesting. I received, my wife and I, we were away for part of the winter, and we got home in, I think it was February 19th. And in the mail, so we picked up all of our mail, and in the mail was this encroachment application that was sent out earlier, like I think on January or so, like, much earlier, but we had been away for quite a while. But we received this, and I actually couldn't believe what I was reading. And I was quite concerned, but what was the worst part of it is I had until the 23rd, this is the 19th. I had till the 23rd to file an objection with a fee and get it to the Idaho Department of Lands, and I'm in Calgary. So, of course, we thank goodness for email, and we were able to take care of that. But so initially, my primary concern related to the potential impact of the proposed expansion. It was what the expansion how it would impact the navigation within the lagoon and restricting access to our property. However, after I spent more time reviewing the application, the history and development of the lagoon, and the applicable regulatory framework, it was clear that the proposal raises a broader set of considerations and potential impacts that Idaho law is required to contribute. So as I said, I'm grateful for this process. It gives us an opportunity to present concerns that I don't think anyone has really given consideration to, including, I believe, the board of directors for our community. And I have nothing against our board of directors even submitting this. I don't feel it was well communicated to the community, but that's not the issue here today, and I'm not concerned about that. And I work with Cheryl. I am the insurance advocate and representative on our Sourdough Point Community Insurance Committee. And she's a pleasure to work with, but I think she's highly professional and look forward to continuing to work with her there. Simply wanted to clear the air on that so that people, you know, there's nothing contentious here. We're just trying to deal with the issues and the potential consequences. Okay. I want to also point out that that I also realize that members of our community all have different perspectives. We have a lakefront lot, and that lakefront does not sit on the lagoon. The lagoon actually is only the island wraps the lagoon. This is no longer a lagoon. There is an open channel at the north end and at the south end. If you look up definition of lagoon, this is not a lagoon. So right at the outset, any minute by the board of directors or from the annual meeting that talks about locating the docks in the lagoon, take a look at what the lagoon really is, because the proposal is well outside the actual lagoon. So that's just a minor point. But we have a lakeshore property. There's a number of other lakeshore properties on this part of the waterway. And I'm going to call it a waterway. And I think historically, in some of the original encroachment permit applications by our community, they called it a waterway. In fact, when they opened that breach, the permit application, and it warmed my heart to see this, and the vision of our forefathers, the vision of those way back in 90 something, when they opened that causeway. What great vision for them to do that, and how that changed the water quality and changed so much. But when they opened that, this was no longer a lagoon. And because that is a channel of water coming through Lake Monterey. And I think the Idaho Department of Lands should give that consideration too, because it's not a lagoon, and that just changes everything in terms of the passage of the navigation through that area. So as we go forward here, Kaylee, and I need you to click on this. I got it. So here, this is just an image of the proposed encroachment. You can see that, and we've seen it before. So I just wanted to pull that out. Things that are interesting as I look at that. I'm not sure exactly what time of year that, I assume it's a Google Earth shot, but you can see the deeper water down that center trench, so to speak, where the opening comes from the north, and you can see the water goes right through to the south. And as the water is shallow on the left side, or the west side, or the east side for that matter, there's only one passage, and it's coming right down the middle. And quite frankly, it's coming right down where that encroachment is going to sit. So maybe in the middle of the summer, no problem, you can work your way around it. But if you're out there maybe in the end of April or the end of May, when the water starts coming in, you cannot get around there. And such encroachment is going to be impacting navigability or navigation right then. We're gonna get to that a little bit more. So this is the area again that we're talking about. You can see that little channel of water. So this is not oriented north-south, so that kind of towards the right corner of your screen, that is actually pretty much due north, and the channel comes right through there. And while it pops into my head, I want to comment as well. This is clearly a channel for water, for navigation and for vessels. And so sure, I can't get my boat through there. And some of you can't get your boat through there, but there are boats going through there all day, every day. And we have our property is right close there. So the boats may not be big, but they are boats, and the navigation and the rights to navigate this lake belongs to those that are on paddleboards, on kayaks, on flotation devices, on little zodiacs or inboard outboard jet skis, and even some kind of outboard motor boats. They will go through there different times of the year as well. So just to be clear, that is a highway for navigation on this through that passageway. And I think it's the federal government that described navigation being like a highway. And so, and we're going to talk about that. So I do not want to diminish what that corridor is about, because the Idaho Department of Lands is to protect navigation, and not just for those that have boats that are big that can't fit under there, but for anyone to enjoy the lake beds and the beauties and the opportunity to navigate the boat. So I'm going to refer to this is Idaho Legislature 58 point, I think it's chapter 58. Sorry, I don't have the exact reference. I think some of you will be aware of it. And so I'm not as prepared as I should have been there to quote that exactly, but I will give the exact language of this. I did here. Okay, Title 58, Chapter 13, encroachment on navigable lake, the legislative intent. The legislature of the state of Idaho hereby declares, I love the way this is worded, because it is a proclamation to the people of Idaho as to what the legislature believes and what they're proclaiming about, and I'll carry on, hereby declares that the public health, interest, safety, and welfare requires that all encroachments upon, in, or above the beds of or waters of navigable lakes of the state be regulated. And so why should they be regulated? They regulate them in the order that the protection of property, this is why they're regulated. This is why you get an encroachment permit. Because the state is responsible and wants to provide protection to property, navigation, not lines of navigability. That's totally different. So I'm actually happy we cleared that up, because that doesn't matter. But navigation, fish and wildlife habitats, aquatic life, recreation. So all of these things matter. And when you think about this encroachment, you got to think about all of this, the impacts here. Aesthetic beauty, about that, and water quality. That all of these things be given due consideration and weighed against the navigational or economic necessity or justification for or benefit to be derived. So there's a lot to be considered. It's not just whether or not you can get a boat through that little passage. There's so much more here. The governing question is not simply whether someone wants more dock space or even has the right to more dock space. The governing question is whether the proposed encroachment interferes with the public interest that the Idaho law is required to protect. That's what's at stake. So IDAPA 20.03.0.04. So I'm not sure if this is what you indicated was out of date. I'm gonna quote this.
Which one?
Well, IDAPA.
IDAPA.
IDAPA. Okay, we're Canadian. We have different accents. So IDAPA 20.03.04.
Which?
The department's own regulatory language states.
What subsection?
I'm sorry. 20.03.04.
What rule number?
Okay, I'll have to get back to you on that.
Mr. Amer might be able to help you out.
This guy knows it. It's similar to the one I just read. So that's
The
the
policy statement, I believe it's 12.
Policy 00011.
Is it, let's, okay,
Now codified at 012.
Should I carry on?
So I'm going to grant the department's objection to the use of policies 011 as effective with an effective date of 9/13/1990, whereas the current administrative rules have an effective date of March 18th, 2022 under that same section. Just on a quick scan, it doesn't look like the language has changed. We had a period of time in the Idaho legislature where rules were not being adopted and needed to be readopted, so it very well could be the 1990 rule, but I will ask that for purposes of your argument, you read from the policy as it exists
Thank you for
today.
your tolerance. If I had Kayleen's education, I'd be way more prepared here.
Okay, so to quote from Idaho Administrative Code, which follows the legislative statement that I just read, but reinforces these same principles, it states, it is the express policy of the state of Idaho that the public health, interest, safety, and welfare requires that all encroachments upon, in, or above the beds or waters of navigable lakes of the state be regulated in order that the protection of property. So again, we're talking about what is required, what the Idaho Department of Lands, what their focus is, in order that the protection of property, navigation, aquatic life, recreation, aesthetic beauty, and water quality be given due consideration and weighed against the navigational or economic necessity or justification for or benefit to be derived from the proposed encroachment. Moreover, it is the responsibility of the State Board of Land Commissioners to regulate and control the use or disposition of state-owned lake beds so as to provide for their commercial, navigational, recreational, or other public use. So that is their responsibility to ensure, to protect navigation, recreation, etc. Thank you so much. Also stated in the state legislative statements, this is back to chapter 13, title 58, it states, the board shall consider unreasonable adverse effect upon adjacent property and undue interference with navigation, the most important factors to be considered. So there's nothing more important than for them to consider the impact on property and the impact on navigation. So again, my goal here is to assist the department in evaluating how proposed encroachment will indeed negatively impact several of these protected interests. For those online, now catching up some of these slides. Public trust evaluation responsibility, IDL, must balance, this is on the screen, balance proposed encroachments against the impacts to public trust values, again, navigation, adjacent property, recreation, fish and wildlife habitat, aquatic life, water quality, aesthetic beauty, public safety, and welfare. Okay, so let's talk about the protection of navigation. Idaho law requires the protection of navigation. Idaho Code 58-1306, board shall consider, as stated, unreasonable adverse effect on adjacent property and undue interference with navigation, the most important factors.
Again, just repeat the various values that they need to protect. And of course, this brings us to the image here in front of us is the lagoon. But I just finished saying it's really not the lagoon. It's a waterway, but there is a lagoon on the right side. So on the east, it's a waterway that comes straight down. We talked about line of navigability. I'm not sure if we need to talk much more about it. I understand that the line of navigability is determined by existing legally permitted encroachments, water depths, waterward of below water mark, and other relevant criteria determined by the department. And why navigation generally matters is because as that line of navigability is determined, that line does not state this is where boats can go. What it states when you have the line of navigability, it states this is where encroachments cannot further extend beyond that line. Boats are supported in navigation to wherever they can go. Like the entire waterway, all of Lake Monterey is public and it's protected for navigation, recreation, etc. So I just don't want us to get too caught up and worried about the line of navigation issue. Correction, line of navigability. Yeah, I clicked on the microphone and didn't advance the slide. Comes with age. So,
Mr. Palmer, I'm gonna have you hit pause because I have a feeling that Ms. Richter is trying to formulate an objection to your prior slide. I'll just anticipate her objection being that you have referenced outdated IDAPA rules, any references that are inconsistent with 2003-04 as written and exist today will be disregarded and replaced with the current version of those rules.
But I said it better myself.
Okay, thank you.
I anticipate there may be no change there, but nonetheless.
As I watch her out of the corner of my eye, keyword searching the current regulations, I was anticipating that that's what she was trying to get at.
Problem.
And that I foresee that as an issue and I will be addressing it. I don't disagree with you that there's probably a lot of similarities between the law that you're quoting and the regulations you're quoting and the regulations as they exist today.
Okay, what I'd like to just skip right to is let's talk about line of navigation. And line of navigation, as was
Well,
stated,
let me clarify. So when you say line of navigation, you're using a term different than line of navigability.
correct.
Okay.
So a line of navigation is the path or the direction that any vessel, any boat might travel on waterways. And north, south, whatever direction, when you're on Lake Monterey or any other body of water, again, these are the lake beds, the waters are protected for public use, and you can pretty much travel where you want to travel. But lines of navigation typically are determined, of course, by the operator of the watercraft. And that determination to determine kind of a line of navigation, what is considered as a watercraft owner. I'm a watercraft owner of over 50 years, but nonetheless, you will all, any of you that have watercraft will understand this. So factors that determine the real world navigation conditions would include line of sight navigation, ingress and egress routes. So if there's an entryway through a passageway or an exit, you're going to look at that. So line of sight, how do I get in? How do I get out? Water depth, you're going to consider that. Many of you would have depth detectors in your watercraft to make sure that you're not grounded, so you have sufficient draft to get through certain areas. You're going to look at piers and docks, and certainly piers and docks that are shoreland, that establishes a line of navigability, which I initially thought, okay, that's where you're supposed to go, line of navigability. No, that is just, let's not build encroachments further out into the water than the line of navigability. And so we're staying with line of navigation, totally different. Piers and docks, shoreline hazards, other vessels, all of this affects the line of navigation. If there's swimmers or people recreationally enjoying the water, that affects the line of navigation you choose. The direction of travel, currents, lighting and visibility, wind conditions, all of that impacts you as you operate your watercraft. Operator awareness and experience. These practical conditions are the factors that usually determine where vessels travel. So, line of navigability is a regulatory reference. Line of navigation, again, reflects how vessels actually move through the waterway. The department's responsibility is to protect safe navigation, not simply to measure structures against an estimated pierhead line or line of navigability. So the department's responsibility is to protect navigation. We will take a look at some historical slides which show the development of this particular waterway. Some of these old original permit applications. And we can see how a line of navigation, an established line of navigation because of use was established and supported and recognized even as docks were built and developed many years ago in our community. So of course, the slide there is today. So I would contest that a primary line of navigation is exactly following that red line. Coming in from the north, traveling right through, and kayaks, canoes, paddleboards, sea-doos, watercraft of every nature are doing that every day. My property is right there. I see it every day. Well, I don't see it in the winter, but I do every day. And not just that. That is just one group, but that's the primary group, north-south group. That's the primary group. But they can kind of vary from that. But again, if I'm piloting, if I'm operating a watercraft, I'm going to stay away from those docks on the west side because I know Ken is going to be swimming off the dock because I've seen them swim off the dock. And John and Karen, I've seen their grandkids swimming off the dock. I'm going to steer away from that because I want to be safe. Furthermore, my draft is about 39 inches in my boat. And if I get too close there, I may not be hitting the ground, but I'm churning up the mud. And then that water quality, just the turbulence just becomes a mess. So that's why a boat will follow the best course, safety, and following the principles that I addressed earlier. Okay, so let's just take a peek at some of the historical documents. So this is the earliest document that I could find was the permit application for the proposed causeway. So that's for the same canoe that we were just looking at back here. There it is. And you can see there that there are boat docks, the shoreline boat docks along the island side. So on the east shore, just right around there, the opening to the north, an opening in the causeway that created a channel, highway for navigation for people traveling around the island, which so many of our family do. Those of you that are not down here on the water have families that are on paddleboards, kayaks, etc. This is where they go. They go around the island. This is the route they take. And a boat like mine, sure, I'm going to drive right through there and break down to my dock way at that south end. And yes, I did align my boat dock with that line of navigation because it was an established. It is an established line. That has not changed. So, but here, back originally, I appreciate those that had the vision to do this, to create just a nice body of water and fountain. So this is another image, that shows, I don't know if this is from Apollo 13 or what, who took this image, but I don't know if it's good. But nonetheless, the pathway is there, the highway is there, navigation started then.
Mr. Palmer, could you go back one more picture, please? This is, what's my bridge dimensions? I believe, is that in your SH 59?
What page?
This is on, this is
They
part
are.
of the complete records of, I think it's part of, I know Department of Lands records as well, that's the whole history.
Yes, I'm just looking for the citation in the record.
Is that the document that's on that slide?
Yes, it is.
Okay. So it is found in the record at SH 59. No page numbers on this, but it starts at the top with Causeway, Permit C highlighted. And it looks like it is a document from June 27th of 1995.
16 of 80.
16 of 80?
Appears to be.
16?
Hello.
Okay.
Yeah, and I really like the note on the top of that, that says proposed open travel way. That was the language then. I'm calling it line of navigation.
That doesn't look familiar. Look at this.
You can continue, Mr. Palmer. We're gonna keep shuffling papers over here, so just ignore it.
I'm sorry, I know I took me here for you. So again, this additional image that shows the opening there, probably like the highway, the water highway, boat docks that are on the outside perimeter. And those boat docks are clear of any, they're respecting and clear of that travel way, that line of navigation. Then further permitting was obtained to add additional boat docks. And I can talk about the line of navigability, and we don't need to, but we can still see that with this plan for proposed new boat docks in the ground station, they were respecting the line of navigation, that waterway that was established when they opened up that causeway, because they had the vision to open that up and create that highway south, which is used, it's used more than anything, any causeway, any openings, that those are used more than any of our watercraft. The bridge, coming under the bridge, there's more watercraft come under that than coming into the north, that north opening. Because it's it's the kids, they're on those paddleboards. Okay, this is a Google image of it. And following Chris's line of navigability, kind of sketched one in there on those docks there on the right. But again, it doesn't matter. Spectrum navigation, the line that comes from the top comes right straight through, and that was respected and planned for by those in our community who built those boat docks. Multiple indicators confirmed that navigation corridor, and that's what we're talking about. It's not just protecting, well, it's protecting navigation, but that means protecting the navigation corridor. Like all of the navigable waters, we need to protect. And as we expand any boat docks, we encroach onto navigable waters. So multiple indicators confirming the navigation corridor there is that there is breach to the breach to bridge line of sight travel. There's the deeper central basin. This is why some of us would take that route. There's the historic dock placement, avoiding the corridor. There's also a water intake pipeline following the deeper water. And Bob has confirmed to me that that pipe in the water just basically follows exactly the red line of navigability, but that's where the pipe is that brings us fresh water. And that is laid there to protect it. It's in the deeper water for a reason. So that just confirms where the deep water is. And vessel maneuvering, et cetera, around existing docks, that impacts the line of navigation or that corridor. So that is an established route currently. So over time, things started to pinch or squeeze that line of navigation, that highway. And this is where we're at today. So there's a little difference if you look at this compared to that. So you can see there's a little more room there on this route in terms of space, distance from the public boat slips. But there's still room, it's still pretty good. And it's interesting how Sourdough Point actually put an angle on the structure there. You see how it's not, that main pier does not go straight north and south. On this configuration, they tore out the previous docks, they tilted it to the northeast to make sure that they could get enough boat slips in there to not impair that highway coming north-south. We can see it. It was all part of the plan. It was part of their permit. So that's where we're at today. And so as we see that, we can see that, okay, we don't have much more room there. You can definitely add more docks there and you can get through it. No one questions that. But it changes that line of sight, vision, visibility. When you come to that north breach, you can see the south ridge and you follow that. You take that away and somebody comes in that north breach, whether it be some casual kayaker or sea-doo operator that comes in there, they will not know if they should go right or left. They don't know. They don't know where the clearance is. There will simply be a dock in front of them. And that creates a problem. That is what an encroachment is. It encroaches into navigation. So here's an interesting picture. So I've thrown everything on this. There's no AI, just a little bit of, just some graphics put on there to identify. So the orange could be line of navigability. We're not talking about line of navigability, even though I keep talking about it. The red arrows, that's the highway. That is the line of navigation, the most used line of navigation in that area. And I'm saying that as one that sees that when I'm there, I see that, and those who have lakeshore properties, we see that more than anybody sees it. I haven't counted, but it's nonstop. You'll see a blue dotted line, and so Bob Chambers, he would confirm that, oh no, correction, green line. So the green line is the water. So it's that water source. It's interesting, everything's kind of following that ideal channel coming north to south, deeper water. And that was selected for the same reasons that boats want to come down that center. Deep water, stay away from what's on the outside, safer, longer season, be able to use that deep water because you don't have the draft clearance in early May if you're trying to come down along that shoreline. But you'll see in there, I've got a bunch of little emojis of people on paddleboards, etc. That's what we've got. Or kayaks, or canoes, or whatever device kids are going around the island with. This isn't just about us adults that drive big boats. It is about everything that floats. That's what navigation is about. It's about everything that's in the water about recreation. Chris made the comment that like, why are we swimming in front of our lakefront properties when we have a swimming area? You know what, the swimming area is beautiful, we love it, but when we are there, why go there? We bought a lakefront property because of the amenities and the beauties that are there that we know are being protected by the Idaho Department of Lands. We know that we have confidence that they will protect us even in this decision. So the boat docks are the boat docks. You can see that these boat docks pushed over the line of navigation slightly, so it had to move slightly to the west to clear. But you'll see the private lots on the west side, the SPOA island, clearly indicated, and the swimming area on the east beach of the island. Idaho Department of Lands rule, no structure may extend beyond the normal accepted line of navigability that's established for use. Okay, I can dismiss that because of what was discussed earlier, but I will say that a structure that extends through a current line of navigation for use, that is a problem. That encroaches into navigation. And if it encroaches into navigation, now just think about what might happen if we added that extra extension. I think it was 26 feet more length. Then you add a couple of boats on the end of that, let's say 8.5 feet each. So we've got 34.5 feet. I'm not good at math, John, that's pretty close. So 34.5 feet, that's a big extension. We're not talking about 3 feet. We're talking 34.5 feet. So this is what you've got. This is what that will look like. So you'll see everything from the last slide, but I haven't moved the red highway or the line of navigation, the primary line of navigation. Yes, we can navigate around that for sure. We can go around it. We might have to say, Ken, get out of the water and come through. There will be swimmers in the water. There will be kayakers, canoers, and small vessels. It's not just about big boy boats. It's about kids. It's about families. It's about recreation. It's about your homes that are on the waterfront there. And for those of you that do not live on the waterfront, your family, your guests, your friends are using the same waters. You put that extension there, that extension, and you changed you changed navigation to look something like this. Okay, so here I've put that encroachment in there at 26 feet. That's the yellow additional encroachment. I put a couple boats on the end of it because whether they are part of these additional boat slips or not, I assume they are. But you have to take into account that measurement. And if they are not part of it, I'm a boater, I know if there's a place to tie up, I'm tying up. Somebody comes in, oh, I can just tie up right there. You're gonna tie up. So whether that's part of it or not, boats will tie up. So now look what happens to that little pinch point. You know, I'm an insurance guy. In fact, I'm a risk manager. 45 years of risk management and assessing risk for clients that are homeowners associations, watercraft owners, watercraft dealers, of every type of insurance. I've done it my whole life, and I will simply tell you, I guess I could say it even in a professional position, I would be advising the Sourdough Point Owners Association, lift that application. Like, do not do that, because the exposure to liability is to our community as well. But putting that aside, the impact, the navigation that changes, and the blind corner that is created for anyone that comes south and now has a blind corner, they can't see where the bridge is. They come around, and the watercraft may be coming from the east that's coming north. That is a tight pinch. At the same time, there might be, Karen, your granddaughter might be there on pathway. And these are big deals. I've had the unfortunate experience of pulling a girl out of the water that got run over by a boat in shallow conditions in a swimming area where the boat drove through the swimming area, wasn't paying attention, drove right over top of the girl that was a triathlon athlete. Maybe this is irrelevant, but I simply want to say these are the conditions where problems exist. The impact of the proposed expansion extends into the established navigation corridor, the eliminating line of sight navigation from breach to bridge. It reduces maneuvering space. Vessels are pushed towards shallower water. Increased navigation conflict and congestion in a confined lagoon. This is the result. This is what will happen. Increased watercraft safety hazards. None of us can sit here and think that, oh no, there would not be an increase in safety hazards. Of course there is. You've got boats passing tightly and there's people in the water potentially. And our grandkids are always in the water. Reduced visibility, blind corners as stated, close proximity to swimmers and small craft. That is where we are today, right there. And changing that creates a big problem. And I'm not done. So I want to be sure that this is current. Just alien, just throw that out. Idaho?
Yes.
I want to say Idaho, like Idaho Pop.
Sorry, to clarify the objection, it's not, not throw it out, but that the current rules, should be used.
Yeah, the current rules are what govern these proceedings.
Okay. So I can't even read this.
Let me find the.
So, Mr. Palmer, I mean, you can read it as written. The current rules are what will apply to my order. But Ms. Richter, for IDL's purpose of asking any additional questions or closing briefings, and not so much for applicant because they're not represented by counsel, I don't need you to quote the black letter rule of law to me. I'm aware of it. I know how to find it. But it's your presentation. You can proceed.
But while we're at a pause, I would like to object to continuing down this line of presentation. I think at this point, I understand Mr. Palmer's point about the line of navigation. And I believe any more information or testimony provided on that point, we are verging into unduly repetitious.
Yeah,
Happy to carry on.
Yeah, so what her objection it relates to, and I agree, is that you're both saying in one breath, the line of navigability, you now understand that you misunderstood that and you meant line of navigation. I have that in my notes to replace where you say line of navigability with this concept of a line of navigation. So I don't know if repeating the rule on line of navigability necessarily furthers these proceedings along, especially because it relates to law that's easily accessible to myself.
Okay, I'm gonna kind of skip a little bit through, but I want to just establish a couple of things. Federal authority on navigation rights protects the public's right to travel on navigable waters. The U.S. Supreme Court precedent defines navigable waters as those used or capable of being used as highways for commerce or travel by vessels. In practice, this means waterways function as public highways and structures cannot obstruct these navigation corridors. I wanted to just give you some images of this particular area. And this would just be somebody paddleboarding down exactly this corridor that we just talked about. Like I kind of thought it was amazing that I even have some of these images, but this is a clear reflection of the area that we're trying to protect. That corridor from the breach straight north, here's somebody on a paddleboard coming right down that route. yes, I did build a boat dock to line up with that. It made sense to do it because it seemed to be an absolute route of navigation. That was finished, lined up to that, but of course, any direction in that lagoon or that waterway is navigable. And I wanted to point out as well, in terms of safety at night, this is where I have it before and after. So this is an image that does show AI, the lights on the very back end of the waterway would represent where my dock is. I come in the north passageway, I see those lights, and it can lead anybody to the bridge. That's South Point. Anybody. This is what it would look like using AI to slide over about 30 some feet with a boat on the end where that is, it's a blind spot and we lose that ability. I have a letter that I would like to share from somebody with respect to some of these principles here. This is from Sourdough Marina.
And it will become, this is not one of the objectionable documents, so this Marina email is within the record and can be referenced by myself for purposes of rendering an order. So I don't necessarily need you to read the entirety of the letters that you have submitted as exhibits, just in the interest of time, because I don't want to get to a position where the public is cut off from providing comments in these proceedings because we go to a late hour.
Yep.
And again, I'd like to, again, object to continuing to discuss the line of navigation or navigability. I think that Mr. Palmer's exhibits speak for themselves and he has made his argument. And I think that if there are additional points of issue that he would like to raise, I would request that we move on.
Okay, so can I ask, so this letter, is this something that you could consider later? I don't need to go through it.
Yes.
But I would just like to have you review this from a experienced watercraft organization dealer.
Mr. Palmer, I did review all of your exhibits. I'm aware of what they say and the content therein. Every exhibit so far has been admitted into this record without objection, with the exception of, and these are the ones I can't necessarily consider until I rule on the objections, is SH 38 and SH 21. Every other exhibit is in the record, part of these administrative proceedings, and can be considered by me in writing an order and by the director in his final order.
And for the record, it does appear that this is SH 47.
SH 47, correct. And then I will note, I need to rule on Ms. Richter's objection. I'm going to give you a little bit of leeway because you are self-represented in these proceedings. It is getting repetitive. But I'm overruling her objection in that I am fully capable of distinguishing between line of navigability and as it's used in your documents versus what you mean, which is line of navigation.
Well, in my documents, I think I was using both terms. Like, I understand what line of navigability is, and line of navigation is different. So I was actually coming to a point, or had to come to a point where here's the difference between the two, but I just simply dismissed the navigability portion. So, but
Right.
I think we understand it too.
I think I heard you say that as to your objection to the line of an encroachment that seeks to exceed beyond the line of navigability, that you have withdrawn that objection and that the objection's more towards the line of navigation that you've discussed.
Well, I would definitely still maintain a position that if there's a encroachment that moves beyond the line of navigability, I would be opposed to that. But if that is not a line of navigability, based on statements that were made by Mr. Abrams, then either way, it still encroaches into lines of navigation.
Okay, I understand that distinction.
And I'll just clarify, my objection is to considering, to proceeding discussing navigation, regardless of whether you refer to it as sign of navigability or navigation at
Yeah,
all. We could just move on to, yeah,
Understood.
that's,
Okay, so I was gonna take you for a boat ride, literally down that line of navigation, but we won't do that. So, but
Your presentation without objection is also part of this administrative record, so it's something that can be reviewed at a later date. So the person you're persuading in these proceedings is me. Unfortunately it's not this fine audience that we have here today.
okay, and I understand that. There's no vote. The vote that took place before it was full. Understood.
Okay.
Okay, so with respect to aesthetic values, I'm gonna have everyone just go for a little boat ride with me, because this is what we're protecting. So there's navigation is part of it, but aesthetics is also. I'm driving straight from the south opening to the north opening. The channel we're talking about, I can't even believe I have this video, but it gives you an idea of exactly aesthetically and the recreational value and the beauty of this waterway that we're trying to protect. I'm right straight from the bridge, going straight. Now driving through where that encroachment would be there. So we're going straight. We would now be bumping into docks. In fact, I'm going to look to the right there and you can see how close I am, but this is that straight line. A lot of empty boat slips there. I'm just saying.
Just saying. Just saying.
Okay, so this is about aesthetic value and the Idaho Department of Lands protecting the beauties, the aesthetic value. Move away from, I'm gonna move away from lake bed value factors as well. That's related to navigation. Skip through that. A statement from Bob Chambers, who is the water guru for Sourdough Point. In a statement to me by email, he said, I think the addition of 2 docks on the west side, member-owned floating dock system would be problematic. The department must consider whether adding additional dock structures further into the open water supports the lake bed value factors or reduces it. And with waters that rise and drop, when we have low waters, as I mentioned earlier, there's other challenges. Fish and wildlife habitat, I can be really quick there. I'm not sure that there's any difference, any change. Protection of recreation and public safety. Public health, interest in safety and welfare requires that all encroachments upon navigable lakes be regulated in order that the protection of property, navigation, and recreation be given due consideration. I've addressed that somewhat. There is a document here that has U.S. Coast Guard boating safety statistics. And just to get to right to the point, narrow corridors plus docks plus swimmers equals higher accident risk. That is from 2023 U.S. Coast Guard boating safety statistics. You can get into a lot of it, but I simply want to emphasize we have issues if we narrow that channel. This is the channel. This is people enjoying. This is the recreational value. I'm not talking navigation now. I'm talking swimming in that area on that channel. And you can see it goes right all the way up to that opening in the north. Again, looking through photos, I was surprised to even find this, but it just affirms that yes, this is an area that people use for recreation. Paddleboards, recreation. We're protecting recreation. You can skip through this. But I can't emphasize enough how this is a critical recreation area, in particular for those that are lakefront here, and there's several of us homeowners, but not just that, members of the community. This is a photo I just took at our place. There's 17 kids on our property. I don't know the name of any of them. They are not my grandkids. I don't know the name of any of them. So that is absolutely the case. I do not know the name of any of them. Actually, Cindy, you know the name of one of them. Alec.
Oh, yeah.
So, so Alec was there because he would always come over and talk to us. But the other kids were picking cherries, etc. These are the kids that are also in the water, enjoying the water. Okay. Okay, and now coming back to Chris's point, and that is the inland and the common area guidelines, we've raised a concern there. Chris said boats are not allowed in the swimming area. My concern there, or not concern, the reason I brought that up is it's very important to Sourdough Point Owner Association that no boats be in the swimming area over on the east side of the island. And so it's recognized by SPOA that let's not have boats over there where the kids are. And of course, I'm not saying let's not have boats in that channel we're trying to protect. I'm simply saying boats are going to be in close proximity to those kids. So we know that we don't want to have boats in that other area. And those of us on that shoreline recognize boats will be there, but they're sharing it with swimmers and little watercraft. So we need larger channels, not about just two big boats passing.
So, Mr. Palmer, I do have a question. Are you contending that the area, I know you've argued against the term lagoon, but it's the one that's front of mind, that the lagoon area is a posted designated swimming spot?
No.
It's not.
So the lagoon area is not, no.
Okay,
What the channel we're talking about? No, what is it is, it's a designated swimming, kayaking, canoeing, and boating spot.
and I understand that there's just a distinction in some prior IDL decisions
Yes.
between a posted designated swimming spot and just a place where people swim.
This is a shared channel, and I think we need to be very clear on that. This is not just a boating channel. This is shared with swimmers, shared with small craft, small flotation devices. Let's remember, there's also a current. There's a current that comes north and south there. So that's why that's another reason it's used as a recreational area.
Understood. I understand all those points. I just needed to figure out if you were making the argument that it was posted designated swimming area in the lagoon, and it sounds like you said no.
No.
It is not.
No.
My next question is, how much longer is your presentation? Because I'm getting close to needing a comfort break. But if you're near the end, I'd say just finish up where you're at and we'll take the break then. But if you've got quite a bit more, then,
I do have a little bit more, but I will try to be much more efficient on it.
okay,
So maybe.
proceed and I will let you know if it gets urgent.
Now, but.
Nope, just keep going.
And just to note for the record, that is SH 48.
Yes, I wrote it in my notes. I didn't say it out loud.
Interesting note here, at the swimming area on the east side of the island, our community did put up a buoy, kind of a safety line that was 174 feet off of the shore. You can see measurements there. If we looked at this recreational corridor used for recreation, swimmers, boats, etc., 174 feet. If 174 feet was the safe distance that SPOA felt was important for just swimmers, well, 174 feet on that other side goes well into the current docks. So it just shows that this is tight space here, and it's shared space, both included. So here I did want to invite, I have a letter from a resident that talks about safety, recreation aspect of it as a witness. You have that letter.
I do.
I would almost need you to read it, but I want to. And the person who wrote the letter is actually here, but I'm happy that you still do it.
I've read the letter. I don't necessarily need you to read it or recite it or summarize it for me. And if the author is here to testify, he can confirm or deny whether that letter is what he wrote and what he intends his viewpoint to be on this proposal.
Page 47.
And it is in the record as SH 47,
Yes.
page.
1, 2, 3. 11.
Page 11.
Ken, is there anything that you want to say on that?
I'm gonna have to place him under oath before we can do that, so that's okay. So I will do that at the public comment
Oh, absolutely.
phase. Yes.
Ah, understood. Okay, so the letter, if I can sum it up a little bit, reducing public navigation to those lots that would feel less safe. Several kayakers stand out of those. He talks about his experience. The letter, Idaho Department of Lands has this. Leslie, you have it for the record to be considered in any decisions.
Yes.
But Ken, I thank you for presenting that letter because it clearly states your concern, that is a concern shared by so many. In addition to that, and so I will also mention, so Ken does have, he owns one of the properties on that water, that area of water. Also from Michael Korn, also an owner of property there, and from his wife Diane Korn. I believe if I'm not incorrect, they own 2 properties, 2 adjacent properties side by side. So this represents 2 different property owners on the same area. We have many concerns about adding the existing floating docks. This addition would encroach on the waterway, pushing boat traffic closer to the fragile, eroding shoreline.
I'm going to object to Mr. Palmer reading these letters. The letters are in the record. They speak for themselves. Mr. Korn may be here to also speak for himself. Mr. Korn is not an identified witness for the objector.
I'm gonna sustain it just because we're now getting to limiting the public participation portion to potentially less than an hour.
But nonetheless, the letter will be considered.
So everything is in the record with the exception of SH 38 and SH 21. So every document you have offered is part of the administrative record and properly considered in these proceedings.
Okay, so on another matter, and let's see, just tell me when you want to break, but I've got to talk about property values.
I'm just gonna have you move past any more citations to the law, just given how late into the evening we're getting.
Okay.
Because I can reference the law.
Understood. And I guess because of my inexperience in this, I simply wanted to be sure that the letters, the documents, the statements will be equally considered, even if not presented in this meeting.
Absolutely. Much like you saw IDL reference none of their exhibits in these proceedings, but I can assign the weight to those documents based on what they are. The only exception was asking them to clarify those exhibits that were sent later this afternoon that I didn't have as much time with as the rest of the record in these proceedings.
Okay, so we appreciate that. I'm just going to skip along, and you have a letter from Ty Hall, who has experience in property values.
Yep.
Gave his opinion on the potential diminished property values.
Yep, that's in the record also at FS 47.
Okay. Aesthetic beauty, there's not much I would say there other than showing images. And we talked about that a little bit already, but just protecting aesthetic beauty it is my contention that, that is being affected, that there's an impact to aesthetic beauty as well. And I could talk about it more, but that picture says it all. Like if a picture says it, paints 1,000 words, that is what we're trying to protect. Right there, aesthetic beauty. So I'm trying to be mindful and do it to follow exactly what you'd like me to do. Let's see. But what I fear is that we get the message across so that if the navigation point wasn't impactful enough, the aesthetic beauty, I want it to be a factor. I want it clearly noted that that is what we are contending. There is an impact there. Okay.
I have found your picture and I am identifying it in the record as to the point you're making.
Thank you. Okay, so another one, and this is interesting to me as I did research, and I had no idea of this issue. But I had a good visit with a resident that's been here a long time, John. And John is here and would like to share a letter that he has written. And it's part of the evidence that I've presented.
Okay, and so that's part of the record, and I believe if he's here, a majority of folks are signed up to testify as public participants, and and he is as well, so he will be given his opportunity.
Okay.
When it's time for.
Not right now. Right? I'll be here.
Oh. She's not now, she's, okay. When it's.
Yeah, when it's the public component.
Okay, and I will just, to get rid of my slides, just to give you the image of this. It's not AI, it's just some graphics that this represents the water flow that comes north to south in that lagoon that has helped refresh and give circulation to it. And are concerned that the encroachment would have this effect. It literally puts a dike in front of that north-south water and would have impact on it. You'd still get some coming around it, but those, I believe the pontoons underneath there would run horizontally, and that will impact the circulation. But John can speak to that later. I'm going to move on to it. You know, I think I'm going to try to just get a bunch of stuff that I was considering. I was concerned about some of the irregularities in the application. And to be honest, I think there's some questions that are not great questions that talk about boat or dock lengths, etc., that don't help give clarity as to the length of the actual structure that is being built. But I'm going to skip through that. I want to just comment on this. This is, I think, a document that Chris, you put this one up?
I shared the same motion that Carl Letter put up.
Yeah, so that is in the record at SD 03.
That clearly establishes the area that boat docks were approved for construction. And this comes down to the Sourdough Homeowners Association that the proposed area that the boat dock would extend to does not seem to be within current structure, which the motion was. It extends beyond what the current structure is. So that would concern me. Ooh. So I want to also just bring up DAPA 20, Rule 20.03.04.
Okay, relating to the length of shoreline
Yep.
and the square footage of the community dock. The spirit of the rule is correct. Right, the language of the rule can be corrected, so.
In that rule, Idaho rule, it states moorage facilities will be limited in size as a function of the length of shoreline dedicated to the community dock. The surface decking area of the community dock is limited to the product, the length of the shoreline multiplied by 7 square feet per lineal feet, or a minimum of 700 feet. Bottom line is, in the application, SOA indicated, I think, that the footage that this is based on is about 4,300 feet. But the rule here states that the measurement must be based on the shoreline that is dedicated to the community dock, which is clearly confirmed in the motion with the indication, the drawing that says this is the area that we build docks. And the footage there is not 4,300 feet. 4,300 feet, I believe, is the circumference of the island. So the footage is about 1,000 and something. And so if we focus, if we recognize that the moorage facilities must be limited in size as a function of the length of the shoreline dedicated to the community dock. In other words, inside that little lagoon portion, there is not sufficient footage there in the calculation to expand any further. We've already met the maximum size. I would have addressed alternatives. Don't need to do that.
But your slideshow is going to be provided and admitted into the record?
Yes.
Okay.
And then finally, I want to present a witness statement from Clearwater Engineering. Clearwater Engineering, Nicole Costella, professional engineer, actually participates in quite a number of hearings of this nature. She is in Sandpoint, and she provided her own opinions on all of this. And I would like to just in conclusion, just review that.
And her position is in the record at SH 47 as well.
Page 6.
So do you mind if I just read that entire letter? That would be the end of my presentation.
I do because I'm getting desperate for a break. But what I will do is I will leave my exhibit binder open for purposes of the public who would like to review that letter during the break on their own, if that's okay by you.
Okay.
I have read her letter. I understand her letter.
Okay.
And I understand how it interplays with the testimony that you have provided here today.
Do you mind if I take 1 minute and sum it up?
Sure.
Okay. So she covers a number of things.
I'm sorry, I have to object. The letter is in the record. It speaks for itself, and I object to Mr. Palmer as characterizing the record as anything other than what it states on its face.
Fair enough. I'm gonna overrule the objection and give Mr. Palmer his 1 minute to the extent that what he thinks the letter says versus what the actual letter says. I'm capable of discerning those two disagreements.
Well, she states 3 points in particular. It is my interpretation that the application is not compliant with IDAPA 20.03.04 regarding allowed dock areas based on shoreline frontage. She provided her own measurements, her own calculation, and just indicated that it is not in compliance. So already we have an issue there. She also stated it is her opinion that the proposed encroachment would interfere with the existing normal line of navigability established. She also stated it is my opinion that the proposed encroachment would have a direct impact on water quality in the lagoon. This is from Clearwater Engineering. And so those are her 3 points. She gives reasoning and information behind that with her professional opinion. And with that, I would just close everything that I have to say and thank Leslie and the Idaho Department of Lands for your time and allowing me to present some of these concerns and objections.
Well, I have a feeling that IDL is going to have potentially some questions for you. The applicant may have some questions for you. So while we're on our break, don't pack up everything and move out of the hot seat. We'll be on a break here. Let's take 5 minutes till 7:02. So, okay, so folks, we are at 7:03. We have a hard stop to be out of here by 8. That is a promise we make to janitorial services so that they can do what they have to do. So with that, we are going to get started. I will be putting limits on the number of minutes for public testimony at this point in time to make sure that we get through everything we need to get through. There may be house cleaning items that we need to discuss at the end of the proceeding. I do need to rule on the objections to the documents. So, as to SH 21, and that Moorhead is not a recognized dock owner pursuant to the HOA's position, I can weigh that, and assign value to that document. So I am going to be admitting SH 21. Adds to IDL's remaining objection as to SH 38. I am going to grant that objection and reject that document in part because it does have other attachments to it. So just the portion of that exhibit that relates to the outdated IDAPA regulations, and that I am going to sua sponte replace it with the current IDAPA regulations. I don't necessarily need those to be an exhibit in the administrative record.
They're IDL 13.
What?
They're IDL 13.
IDL 13. They are in the record at IDL 13. I don't need those as an exhibit in these proceedings because I am free to reference the law, whether they're an exhibit or not. So that's the ruling on those objections. I'm hoping that during the break that you and Mr. Palmer had a conversation, and that's why he's back in the audience. But do you have any questions, Ms. Richter, for Mr. Palmer?
We did not have a conversation. I have not quite collected my thoughts. Would it be possible if I passed on asking them any questions until after the applicants get a chance?
Yes. Do the applicants have any questions for Mr. Palmer?
Yes.
Okay, so Mr. Palmer, I'm going to have you come sit in a seat so that there's eye contact and we're not talking over shoulders. And then, Mr. Good, I'm gonna ask that you use the microphone. You may have-
Can I defer to my colleague Tim?
Does he have the authority to represent the HOA in these proceedings?
What is it? Yes, Chris has the authority. He's on our dock committee.
Tim,
So Tim, I'm sorry. Tim is on our dock committee and he's part of the group that put all this together and represents the SPOA board.
Okay, so with that, Mr. Personius, given that you have the authority from the president of the board of the Homeowners Association to represent the applicant in these proceedings for these purposes, I will rely on that to the extent anybody with the HOA disagrees with the president's assessment. That's a separate board issue that you can take up at a later date. It's not for purposes of these proceedings. So floor is yours, Tim.
And you want me up here?
Yeah, and I'm gonna keep standing because I'm done with metal chairs for a minute.
I think we all are. So Kevin, just a few things. I know we're all trying to hurry, so I will try and hurry. So your letter from Jarrett Moss of Tobler Marina, talking about the safety concerns. I guess a couple observations. We measured using some Google Earth measuring tools, and Tobler Marina has a series of 28-foot docks that have 44-foot fairways or widths between them. And they have some large 38-foot boat slips that have a 60-foot fairway between them. So I find it hard to believe that Jarrett's comments about our proposed 67-foot fairway creates some kind of issue that his own marina or whoever he is, I'm not sure what his position is with Tobler Marina, but apparently those widths are okay at Tobler Marina, but he's suggesting they shouldn't be okay here. So I found that a troubling piece of testimony. I then called Tobler Marina today and asked them if they allow swimming in their marina, and they said absolutely not. No swimming, no fishing, and they're a little lax on paddle boards because so many people are doing it, but they don't like them either because of safety concerns. So I found his testimony to be not very compelling for those reasons.
Did he testify about his marina?
Well, he was talking about our situation,
Yeah.
and he works for Tobler Marina, and so I'm questioning his.
Well, he may feel the same way about theirs. Their marina.
So Mr. Personius, this would go more, less of a question to Mr. Palmer, but more of a statement that you may want to make in closings.
Okay. And to be fair, we had hoped these folks would be here as witnesses. They were listed as witnesses at one point, and we thought we could ask them these questions, but they're not. The next one.
I too hoped, but the record, I hope that they would as well. It was just such a short, compressed timeline to come together.
The email from Bob Chambers, and perhaps Mr. Chambers can rectify this when he speaks. I believe you are going to talk, Bob. You're not signed up. Okay. There's a statement in here that Bob says the water is 15 feet deep underneath the floating dock system. And I think we're going to see tomorrow that that's not accurate. It's about 7 feet deep.
Yeah, I think it's a little deeper than, I think it's 8 to 9 feet in certain. Yeah, so, and I agree that I think this, I don't think it's 16 feet either, but, so I don't, I'm okay with that. I think the point that he makes in that statement is that that is the deepest part. That is the deep channel from north-south. He had the, maybe the measurement may not have been accurate.
So,
But it reflected.
Mr. Palmer, I don't want you to try to assign meaning to someone
Sure.
else's statements. Just, I'm gonna try to control this a little bit more than I normally do because we're getting so late into the evening.
Okay. And I believe when we get to the discussion about tomorrow's visit, I think that will be very illuminating to be able to see what the depths are, because I don't think there's any place 15 feet deep we're doing and with Dave.
I don't think there is.
Maybe the last question is the Clearwater engineer in your last statement. We had a number of questions. Did you pay for this assessment?
That relevant?
Yeah. Was this a?
It doesn't weigh towards residency, so I'll ask the James.
Yes, I did.
So you hired Nicole Costello. Point out she's a professional engineer, but she appears to be giving 2 legal opinions and a biological opinion in her thing here. And she's an engineer.
I can't comment on that. She gave that report. I asked her if she'd look at that.
I guess what's the really trouble.
And I've never met her. Say that.
Okay. The calculation of square footage that you used, or that she used and you discussed here, says that SPOA should only have 7,021 square feet of dock space for our community docks, and we currently have 7,433. That would indicate, so this is not counting new docks, this is the existing docks. So your testimony document here is basically telling us that we have to remove 5 4x20-foot docks, existing community docks, in order to be compliant with our permit.
Nobody's asked you to remove anything. That would be.
But that's the testimony here, is if for us to be in compliance. She says that we can only have 7,021 square feet, and we currently have 7,433.
She said nothing about removing.
That's what she's telling.
Okay, that's all. Thank you.
Okay, thank you. Richter.
Thank you. With respect to Jarrett Moss of Tobler Marina,
you want the microphone?
No, give me just 1 second, please. With respect to Jarrett Moss of Tobler Marina, SH 47, page 1, his position is listed as sales associate in his email signature. My understanding is that Mr. Moss is a boat salesman. Is that correct?
He is a boat salesman.
Okay, and so he does
He's
not,
not selling me a boat. He is.
right?
But a boat salesman with a lot of experience with boats and bringing them in and out of marinas to test drive.
Mhm. But his expertise, his experience within this marina, his position with Tobler Marina is in sales. Is that correct?
Well, it's in sales and watercraft test driving. In and out of marinas,
With
which is
respect,
part of the responsibilities of a salesperson that works at marinas.
thank you. With respect to the Clearwater engineering letter from Nicole Costello, this is SH 47, pages 6 and 7. Do you know what materials Ms. Costello used to review to come to her conclusions?
I don't know completely what she used. I mean, she talked about a measuring instrument or tool that is very,
Mr. Palmer, why don't you focus on what materials you provided Ms. Costello prior to her writing this letter? That would probably be the faster way if you don't know what she reviewed.
so I think I provided her with a copy of the application. A copy of the, well, you know what, I would have to go back and see. I don't want to just make statements that I provided her with this or that. I can certainly undertake to let you know exactly what I provided her with.
Okay, and because we're getting later into the evening, we will be I will be asking for written closings in this proceeding if applicant and IDL need longer than April 15th, that's fine. I can give another week after that and you can supplement the record with recalling your recollection of what you provided her, and it will be the same.
It'll all be by email. I'll have it.
Sworn with, it will have the same weight as sworn testimony here today.
And just to follow up on the shoreline frontage calculation, do you know whether Ms. Costello has any experience calculating shoreline frontage and considering what the applicable frontage is?
Well, I believe she looked at regulations with respect to the shoreline frontage, which included a copy of the document that Idaho Department of Lands requested that I sign and return to them, which had the information about the calculation, how that calculation is to be. Let's find the document. So it's the state of Idaho Department of Lands attachment for encroachment, community docs, requirements, and setbacks. So that document, which was sent to me by the Idaho Department of Lands, that if I wanted to object to the application, I completed that document, and that document had information on that calculation. So she would have referred to that.
I don't believe there's anything else that we need to address here, since you are, your officer is authorizing closing. Written closings.
I am authorizing written closings. All right, Mr. Palmer, you're out of the hot seat unless Mr. Personia's IDL's questions raised any more for you. Okay. So that closes. Is there anything else applicant wanted to put on by way of witnesses in response to objectors' comments?
No.
No? Okay. Anything else IDL would like to address?
No, ma'am.
Okay, so we are to the public comment portion of these proceedings. I will call you up one at a time in no particular order. You will be sworn in. I will ask you to use the microphone and to limit your comments to 3 minutes. Normally I say I will give this cautionary note. I'm going to use my timer. I will say 1 minute and those comments routinely go 5 minutes. So 3 minutes is generous. Make sure they don't go 8, okay? Mr. Palmer, I assume that you have provided all the public testimony that you intend to provide. Okay. Chris, good. Same assumption. You have.
Yes.
Okay, I have Greg Lockert. Come on up.
George.
Oh, sorry, George Lockert. Okay, will you raise your right hand for me? Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay, microphone's right there. It should be on.
I don't need the mic.
Okay, will you spell your last name for the record?
Lochert.
Thank you. You are free to proceed. The floor is yours.
Yes, I've been sourdough for 28 years, a member of sourdough, a property owner. And I totally disagree with the location where these 4 new slips are being proposed. And there's plenty of room on the other areas of the island to put docks. And I feel that Mr. Palmer did a great presentation. And I agree totally with what he said. And that there's no reason to go forward with adding, encroaching on the waterway. There's just no, so anyway, I just like to keep it short. And thank you all for being.
Thank you.
Thank you, Mr. Lockert. For reference, he kept his comments to 1 minute. Good for all of you. Tim Personius, do you have any further comment? Okay. Carl Vetter.
Yeah.
Carl Vetter.
Okay, that's another thing on board. This whole,
Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay, floor is yours.
This whole deal is about something I started, about the deal that went on in 2024. This whole deal is about telling these people, we got a deal. We put it in a bid to put the docks. People wanted 4 new docks. We said, no, we don't want them where you guys wanted them on the outside there. We want them inside the marina there, and we want them inside. That went through, everything's fine. And now we hear, now they're gonna put them on the end of the deal. Well, there's a line made on that thing, but the line goes like this. On 2024, it's on the deal. You guys got the no already. You guys got the yes by the people who said no, it needs to go inside the marina. There is places inside the marina, so I hope you put them there. Thank you.
His last name.
Vetter was spelled Vetter.
Thank you.
And then I have Hugh Slater. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
All right, floor is yours, Mr. Slater.
My question is basically for the Idaho Department of Lands. Has there been a wildlife impact study done in this area? This isn't 1961 anymore. And we need to address, things that, improve the environment. I worked construction for over 30 years. One of the first things I had to address was a wildlife, impact study. And I was just wondering if that's been done.
Fair enough. Mr. Slater, you are free to talk to any of the representatives from IDL. It looks like Mr. Amer is volunteering his time to speak with you after these proceedings. All I can tell you from the record I've reviewed is that all environmental regulatory agencies, so DEQ, and Fish and Game, and there's a third, it's in there, Water Resources, are all sent notices similar to the public. And every agency has, none of those agencies have provided comment with the Department of Fish and Game affirmatively saying they have no comment on this project in this proceedings.
I see.
So, but Mr. Amer is available after this hearing is concluded and he can
Okay.
talk you through what that all means.
Thank you for your time.
Thank you.
Yeah, something about Fish and Game if they're involved or.
There's somebody that's unmuted. I'm gonna, there you go. John Cron. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay, will you spell your last name for the record, please?
CRON.
Great, thank you so much.
A little summary of my objection is there's a strong possibility that water quality within this SBOA low lagoon will be impacted by additional of the proposed docks. Water current through the causeway opening is generated by wave action resulting from the northern winds. Over time, the waves have cleansed the water within the lagoon to a point that now it's safe for swimmers and recreation. We're going to talk about a little history, but maybe I'll skip it. The causeway was built in 1996. The causeway was built. No, it was built as when the development was first developed, and the causeway was not open, did not have the opening until 1996. And so during that period, it had no water flow through it. It basically became scuzzy and
You can use the microphone if you'd like.
louder. Is that louder?
Yeah.
Now it's louder.
Okay, let me see.
Okay.
Test. Dive right into the middle.
If it's easier, that could he submit his
The
statement?
lagoon, before the causeway was opened, is without the water flowing through it. It's just stagnant water and, but we built our dock in 2000.
So Mr. Crum, one thing we can do is, because we also are admitting written public comment in these proceedings, is we can just simply take your statement and written comment and put it in the agency record.
Yes.
Yeah.
I thought it had been.
Yeah.
It's a little bit different.
We'll just submit it as a public comment.
Very long letter to me.
Yeah, the
It'll-
water flow is what. is
It'll be
the
in.
part. The waves, wave action out in the lake, the water comes in through the
causeway and exits onto the ridge.
Yep,
That's what-
we will, this is now part of the record, but there's also what looks like to be a similar version of this letter as part of Mr. Palmer's exhibits that have also been submitted as part of the record.
Yes.
By providing testimony and being placed under oath, this now carries the weight of under oath sworn testimony. I have a Brian Stone. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay,
Yes, been a resident of, Sourdough for 25 years. I own a shoreline dock. I have to navigate the 45-foot section, when I leave, and use my boat, which I, use my boat almost every day in the summer. In the afternoon, we go fishing. Can everybody hear me?
Yeah.
So the distance between the extension of the floating docks, which is the best area to put those docks, still provides, even with a boat on the end, more than probably 65 feet. And I would just end my comments. I totally support the location and the permit as written. Is that current also runs underneath. It's not just wind current. And if there's north wind blowing, it's going to blow through that southerly causeway anyway. So I don't see any water quality issues, which are important to me as a fisherman, by placing those extended docks. And that's the end of my comments. Thank you.
thank you.
Good job.
All right, and then I have a Kevin Richard who was listed as a question mark. Would you like this? No comments from Mr. Richard. All right. Well, that is the end of my public comments. Yes, Mr. Palmer.
Ken Beersford is here. You have his letter. Could you see if he would be willing to just confirm that that letter is?
She said she.
It is.
It's, I mean, the letter is admitted, Mr.
If it has weight, that weight, that's.
I'm not seeing him on my sign-in list. What,
He's right here.
okay,
Right here. What's the deal?
did you not sign in?
I didn't sign.
Just up.
It didn't go.
Okay, yeah. But you do have my letter, correct?
Yes.
I'll go ahead and, was it 47?
Ideal doesn't object to Mr. Here, sorry,
Okay, Mr. Beersford, I'm gonna come put you under oath
yes.
for
47.
purposes of admitting this as sworn testimony into the record rather than a letter as an exhibit. There's,
Okay, you mean.
Come around the side.
do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes,
Okay, can you spell your last name for the record?
Beresford.
Okay, and you have been handed a copy of your letter, which has been admitted as SH 47 last page. Do you confirm that that the content of that letter is consistent with the testimony you desire to provide here today?
Absolutely.
Okay, do you want to provide any other comment?
No, it's all right there, all packed in.
Okay, thank you, Mr. Beersford. All right, that concludes our portion of the public participation of these proceedings. So I will turn to IDL and ask Ms. Richter, is April 15th sufficient time for you to submit closing statements, or do you desire to provide those at a later date?
April 15th is enough time.
April 15th. Mr. Palmer, an applicant, April 15th for purposes of written statements? Okay, I'll actually make it the end of the week to April 17th, so that if we have additional written comments that come in by the April 15th deadline, you can address those in your written closing as well. So with that, we will be closing out these proceedings. It'll be fully submitted on April 15th. Closing statements provided by the parties on April 17th. My order a few weeks after that, with the final director's order no later than 30 days after the April 15th deadline. So with that, the record is closed here tonight and open for public comment for another week. Thank you for all of my online participants. I will be ending the meeting at this time.